Testing. Yeah, I'm confused what the application actually is, because now they're saying they're only going to do takeout, they're not going to use the kitchen for the place next door.
That wasn't my understanding.
No, no.
Let them put it on the record. Yeah, back. If you look back at the minutes. What was this?
The old resolution?
2013.
Right.
They were 11 spaces short. They're supposed to pay $5,000 a spot in the token trust fund.
And they never did?
And it wasn't these people. It was a crossing out.
I thought you couldn't file an application unless you were compliant with the...
Well, you do it after. It was something that was.
I'm saying, I don't know that they can come here when they have a zoning violation.
I don't know if they have a zoning violation. I'm not sure anybody picked up.
I don't know.
Well, I'm not gonna,
It's a fair question.
Huh?
Oh, I don't know, it sounds like a fair question to me. All right, let me try to look this thing up.
Maybe they did pay it.
It says due to parking trust. I don't know if it means it was paid or received.
I wasn't making it up.
Oh, I know.
Yeah,
I read
just-
I
okay.
just read the same thing 5 minutes
All
ago,
right,
so
just-
I was like, I don't know.
Too late. Okay. Okay, good evening, everybody. The regular meeting of the City Cape May Planning Board is now in session, and in compliance with the Open Public Meetings Act of 1975, adequate notice this meeting has been provided. Should any member of this board have reason to believe this meeting is being held in violation of that act, they should so state at this time. Hearing none, we will start with the Pledge of Allegiance. Pledge allegiance.
Mr. Bezaire?
Here.
Mr. Jones?
Here.
Mr. Crowley?
Here.
Mr. Gorgone?
Here.
Mayor Mullick? Councilmember Yeager?
Here.
Mrs. Reed?
Here.
Mr. Lundholm?
Here.
Mr. Malloy?
Here.
Mr. Bedusis?
Here.
Thank you.
I would also ask that everybody mute or turn off their cell phones, please. Okay, we have minutes of August 8th, 2023 for adoption. Thank you, Dennis. Thank you, Mr. Ludholm.
We have a motion by Mr. Crowley, seconded by Mr. Lundholm. Mr. Gorgone?
Abstain.
Councilmember Yeager?
Yes.
Mrs. Reed?
Abstain.
Mr. Crowley?
Aye.
Mr. Lundholm?
Yes.
Mr. Malloy?
Yes.
Mr. Bedusis?
Abstain.
Mr. Jones?
Yes.
Mr. Bezaire?
Yes.
Thank you.
Okay, the application for tonight's meeting is Bogle Investment Properties LLC, 502 Washington Street, Block 1050, Lot 9. Anybody who's going to speak would need to be sworn in.
Okay, who's,
Mr. Monzo?
if you can introduce everybody, I'll swear them in, just put their names in the record if you would. Okay.
Can you turn on your microphone, please? And I'm sorry, we don't have enough to go around for each person. If you could share them, that would be great. Thank you.
So my name is Anthony Monzo from Monzo, Catanese, Delalis. We represent the applicant, which is Bogle Investment Properties LLC. This is the property at 502 Washington Street. It's at the corner of the Washington Street Mall and Decatur. The former bank building became Stewart's, was a bookstore before that, and now it's back to a retail store with a continued kitchen for retail sale of prepared food. With me are Karen Thompson, who is the owner of the retail clothing shop, Mike Slowak is the operator of the retail kitchen, and Paul Farnham is an architect that had prepared plans just to show the design of the interior and to address any questions that the board may have. So I think this is more, not so much a technical application as it is, for the board to determine a fundamental question of jurisdiction based on whether a variance is needed for the use. But I want to give some background because I think it's important. As I stated, this building initially was a bank. Joe and Paul Bogle, and actually Paul is here as well. He's not testifying, but he's here to answer any questions that may come up. They bought it several years ago through Bogle Investments, LLC. It became a bookstore, operated as a bookstore for several years, so the use was retail. And at some point in, I believe, in maybe somewhere around 2010 or so, I don't know the exact year, but 2012, it was converted to Stewart's. And so that was the last site plan application that was presented to the board. It was a change of use. And because it was a change of use, the board needed to analyze the parking because restaurant use, and it was approved as a 92-seat restaurant. Restaurant use has a significantly more amount of parking required than retail, and I believe there were 38 parking spaces required as a part of that site plan application. The variance was granted, the change of use was approved, and I believe there were some parking spaces that were dedicated in the Bank Street parking lot. There was some money paid to the parking trust fund. The parking demand for retail was 15.
Pardon me. So for the record, the mayor has shown up. We just got started, so I don't think you really missed too much, Mr. Mayor. You might want to put your microphone on as well.
Thank you.
So when it was retail, the parking demand was calculated based solely on square footage and employees, and the number, I believe, was 15 parking spaces. At least that's what it's now at retail. It may have been a parking space more or less depending on the number of employees, but the square footage of the building has not changed. When it was converted to restaurant use, it became significantly more intense in terms of parking, and that's what triggered the variances because of the need for 38 parking spaces. So one of the questions that was raised by Mr. Hurlis, and there were two questions, I think, but one really follows the other. The first question is whether this is all one retail use, therefore permitted in the C1 district, or is it two separate uses, which means you would need a variance because only one principal use is permitted in the C1 district or in any district, and there's a general statement in the ordinance in the city code on that. One of the uses, permitted uses in the C1 district is listed as the retail sale of merchandise or prepared foods. Restaurants come under the category of eating establishments, which is a separate use in the C1 district that requires the cooking of food for on-site consumption. So the difference between a takeout restaurant or a takeout food service business and a restaurant is the fact that there's no on-site consumption of food for the sale of retail food. And I do recall the Capoletti's project on West Perry that was set up as a food service business, but there were no seats because it wasn't approved as a restaurant. Had it been approved as a restaurant, it would have been a different use. The parking demands would have been much greater. So there are instances throughout the city. Wawa, for instance, is a retail store, but how much prepared food do they sell? We have ice cream shops throughout Cape May, including Core Brothers, which has no seating inside, and that's a retail use. It's retail sale of prepared food. There are hot dog places that sell hot dogs with no on-site consumption. That's the retail sale of prepared food. So what we have here are, we have two businesses, but they're both engaged in a retail business. And to me, it's not much different than what's going on in Center City Mall, with 9 separate businesses operating all under the category of retail, which is permitted under the code. I mean, you don't, every time there's a change of tenancy in the Center City Mall, it's not considered a change of use. And at one point, just 2 years ago, there was a restaurant on the second floor. When it became a restaurant, it wasn't considered a change of use, did not come to this board. When it went from a restaurant back to retail, it was not considered a change of use, didn't come to the board. So there's precedent throughout the city for various uses in the mall, for instance, Kaleidoscope, Just for Laughs, and a bakery in the back. They're all in one building, all under the category of retail, all a permitted use. So our position is that this is a takeout food service establishment that is focused on retail sale of food for takeout and not on-site consumption. To give you a little bit of a history of this, I mean, this all started with the pandemic. And Karen Thompson, who runs the retail store there, the clothing store, leased it from Bogle Investments. Karen also owns and operates all the Fudge Kitchen stores throughout the county. But she leased that store for retail use. It had a fully functioning kitchen, and it was on the onset of the pandemic when, you know, there was this whole outside-inside dining dilemma. Even when indoor dining was permitted, the executive orders, allowed outdoor dining, and the city had allowed outdoor dining, and Decatur Street was closed. So the Ugly Mug, owned and operated by Mr. Slowak, expanded its seating to include all those tables and chairs outside on Decatur Street, which created a significant demand and burden on his kitchen. So when he saw that there was a fully functioning kitchen at this property at 500 Washington Street, he made a deal with Bogle Investment and with Karen to at least lease out that portion of the building so that he can prepare foods there to help with the service of his customers at the Ugly Mug. And when this evolved into an application, the outdoor dining was diminishing, and we initially were of the opinion that this was something that was critical to the restaurant, but without the outdoor dining on Decatur Street, the Ugly Mug Kitchen fully meets the needs of indoor and patio dining along that business, and the outdoor, or the kitchen at the other side of Decatur was really more functioning as a takeout kitchen. Now, if people come for takeout food, if they call into the Ugly Mug for takeout food, the food is prepared at that kitchen and served from that kitchen. Mike Slowak will testify as to that. It opens up opportunities for DoorDash and other takeout deliveries of food. It happens all over. There are takeout restaurants or takeout food service establishments throughout the county that are focusing on the preparation of food, prepared foods for takeout and off-site consumption, which is what this business is. So we're of the opinion, and we have, we're relying on the code that says retail sale of food, of prepared food or merchandise as coming under the category of retail. Therefore, we look at it as one use, just like you have a bakery and 2 retail stores in one building, just like you have 9 retail stores in another building. In this building, you have 2 retail stores with 2 operators, one serving prepared food, one serving merchandise.
Question.
Merchandise. So we'll go through the testimony on that, and that leads to the second question, because if the question on the first issue is this is one use, this is a permitted use, there's no use variance. And because we have, and I think Mr. Hurlis may agree with me on this, if there's no use variance, we have a change of use from restaurant as stewards to retail. We have a reduction in parking from 38 spaces to 15 spaces. And under section 525-22C, it says a change from one use by right to another use by right in the C1 zone, which does not require additional parking pursuant to section 49 of the zoning code, is permitted without a variance. And I'm paraphrasing, but that's basically what it says. So if the answer to the first question is it's one use, the answer to the second question is you don't need a parking variance, and we therefore just need some testimony to talk about the operational aspect of it, to address some of the safety concerns and other concerns that the board may have, and to address any planning details that Mr. Farnham can
Mr.
address.
Crowley had a question.
I did have a question. Could you give me any examples in town of an establishment in which the food is prepared in one building and walked across the street and served in another building?
All the beachfront hotels,
Well, wait, hold on a second, before, wait a second.
quite a lot of them.
I don't know that I've sworn anyone in, because
Oh,
no
I'm
one said
sorry.
they were
Yeah,
talking
okay.
yet. And I think you want to talk to
Oh,
the
that's fine.
attorney before you go answering questions.
thought it was
So I don't think
yes
you're
to all
even
of us.
applying for that, and that's part of the problem, and that's my question. Is that our board thinks, as I thought when I walked in here, that you're applying to have your restaurant utilize the kitchen across the street and to bring food with servers across Decatur into the Ugly Mug. I'm told right before we started by your attorney that that's not what you're applying for. And I tell you, it's very difficult to prepare for a meeting when you're not doing what's in the application, because they're very different things. So can we just clarify now if you're doing what they think you're doing, or,
Why don't you swear the other three in first?
sure. but
I can answer
don't know
the
that it takes
the
testimony. I
question.
don't know
We
if-
are, and I do understand that. And this application was done a while ago, and it's going back and forth. Actually, I think we submitted it initially almost a year ago, and we had some issues with planning, and, you know, so a lot of things prevented this from getting to the board. And at the time, you know, the things, you know, it was right on the heels of the outdoor dining.
The history's
So-
good. Can you just say what you're applying
So
for?
we're applying for a retail, the retail sale of food for a takeout business only, not as a satellite kitchen for the Ugly Mug.
Okay.
But I can answer Mr. Crowley's question if you,
Let me-
okay, I'm sorry.
His question is arguably moot, right? Because you're not doing that. So the challenge that I'm having at the moment, because now that you've changed the application, it was very clear to me that you had two principal uses in a single building when you were using that building to cook for a sit-in restaurant across the street. That's clearly two uses, okay? I didn't need complicated interpretation for that. That was clear to me. And we have a section that says, each site shall have only one principal building, structure, or use. I appreciate we have a mall that confuses that, but I wasn't around when we approved that. And what that approval says, that approval may say you can have all different stuff in there. So that's not before the board at all. But now that what you're saying is I think your argument is that you have retail sale of goods and prepared food. And since they're both under M in the use regulations, that is therefore a single use.
Correct.
Right? And that is an interpretation of our ordinance relating to a use variance, whether or not you need a use variance. And I do appreciate that planning boards can do interpretations when they run into questions about, well, is the subdivision a cluster? How do we understand clustering? Or this says you can't have an exit on a corner lot, but this really is a peninsula, not a corner lot, so can you have an exit here? I understand they interpret the ordinance all the time, but where you really get in trouble in the case law is when planning boards are interpreting whether or not a use variance is needed. Because use variances are the jurisdiction of the zoning board. And it's really a sticky wicket for the planning board to start saying, well, we don't think you need a use variance. That's a dangerous interpretation, because that's really saying that the zoning board's never even going to get to consider the use variance concept. So I really need some clear law that says that I'm going to let the planning board determine if having retail sale of goods and prepared foods means you can have a takeout restaurant with DoorDash and all these other things pulling up into it, which, by the way, drive-in facilities with window or curb services are not permitted. It says that. On the side of a building that also is a full clothing store. And that's something that had the planning board do seems to me to be incongruous with the zoning board's jurisdiction of doing use variances. So I kind of got to get that straightened out if that's the application.
There's an reported appellate division case, DePietro versus Township of Wayne Planning
Okay.
Board.
Yes,
And in that case, the planning board made a determination as to whether a specific application was a permitted use or not a permitted use. It
Yes.
concluded it was a permitted use, approved the site plan, it was appealed to the law division affirmed it, went to the appellate division. Challenger said, well, we don't think the board the planning board never had jurisdiction to interpret the ordinance as to a use variance. The court rejected that argument. They said if the If somebody opposes or objects to an application because they think it requires a use variance, it's incumbent upon that person, and it's stated in this case, to apply to the zoning board for an interpretation of the ordinance. It's not for the planning board to resolve the dispute between an objector and an applicant. Now, obviously, we applied to the planning board because we are of the opinion it's a permitted use, and the board can make that decision under the DePietro versus Township of Wayne.
But Tony, in fairness, you didn't.
I'm giving you case law, Rick.
I understand that, Tony, you're giving the case law, but you've changed your application in the beginning. So now, it's like you knew that you weren't gonna use the restaurant across the street, and now you've changed the application. So now we're stuck with this challenging question. And I also remember that case, and that was after the fact. So, I had this in Margate. So yeah, sometimes a planning board, in the middle of it all, they do it, and then they're in the appellate division. The appellate division says, well, yeah, they could do it. But that doesn't mean that they have to do it, or that when they're presented with it first and it hits them, I don't know that they have to. It's one thing for the court to look after the fact and say, well, they've already approved this site plan, they've already done this, and we're gonna decide whether it was okay for them to do it, as opposed to, it's here now. And the board has to decide, well, do we wanna do it, or should we have the zoning board do it?
But let me just,
We're here at the
let me
end.
respond to that, because I think this is critical.
Let me see the case, Tony.
This application was filed, again, over a year ago when there was an operational issue with respect to the outdoor dining. So based on the application that you're saying clearly has two different uses, why are we even here? Right? Why? Because now we have a close call.
I don't know.
Now we have a close
application.
call. Now, we were directed to file an application with the planning board for a change of use. That was the direction we got.
From the zoning officer?
Yes. We were directed from Bruce Britton to file an application with the planning board for a change of use. And if you think we don't have a permitted use, we shouldn't be here. But my opinion is the board has the right to determine and has the inherent authority. It's inferred and implied with the powers of a planning board to interpret the ordinance in terms of use, in terms of bulk requirements, in terms of anything that appears in the zoning code. You have the inherent right to interpret the ordinance, and we're asking that you do that. Now we have a case, and I apologize because this was submitted a long time ago, and I probably didn't look at some of the justification for it when it was resubmitted, but things have changed in the past year. The outdoor dining went away along Decatur Street. The need for a satellite kitchen for the Ugly Mug is no longer in existence, but there is a need for takeout food, and it's not and Mr. Were the witnesses sworn in yet? Because he may need to address some questions. I don't think they were. So you may want to just swear them in before I have them make any statements on the record. Rich?
Well, my question is, in order for it to get to this point, the zoning officer had to say, this is what I think it is, and that's why we're here. Now, I don't know if that decision by,
I thought the reason the zoning officer sent it here is because the applicant, in their application says, applicant proposes a change in use. So as soon as they propose it, that's their application. So as soon as they change in use, that's a site plan. That's, am I wrong, Craig, isn't that?
Swear me in.
Craig, you swear to tell the truth, whole truth, nothing but the truth, so we got,
I do.
right?
Yes.
So that's why it goes to the planning board.
But the application disclosed what the uses were, and, in Craig's review memo, he specifically states,
All right, well,
that the applicant must demonstrate that the uses proposed are permitted. This appears to be a satellite kitchen. Prepared food will be brought across the street. Use variance approval from the zoning board may be required. Additional testimony is required to evaluate if the use is permitted. So he's saying in his review memo that testimony before the planning board needs to be put on the record for the board to determine if this is a permitted use, which is where we are now. And to say at this stage of the game that the board shouldn't be interpreting uses as part of its function as a planning board, to me, doesn't make any sense.
okay,
And it's contradictory to the
All right,
case law.
okay, Tony, respectfully, I'm gonna read this case.
Okay.
Having the power to do it and electing to do it are very different things. So I appreciate that maybe they could, maybe they couldn't, but I think it's also the board may say it's a use variance, or we don't know if it's a use variance, shouldn't, so Now that I know what you're actually doing, I want to give it a little thought and read your case, okay? Does everyone mind if I take a minute and read the case? Because
Can I ask a question, just procedurally?
yes,
It's got nothing to do with what you're going to worry about. The attorney just said he applied for this thing a year ago. It's gotten to this point, we've been given materials to study for at least a week based on what is on the table in front of us. Now we're finding out that it's different from the thing we thought we were going to be discussing. I would recommend, if the chair is so disposed, that this thing be somehow tabled or sent back to get the paperwork straight. Because we can't hear one thing and another thing, and we can't do our homework. We can't do our homework at the table.
but in fairness, they think they're making it better. They feel it's less intense. So, I mean, that's what's going on is, and I sympathize with Tony on this. I mean, he's saying it's one thing if we were adding that we were going to go across the street, but they view it as making it better. So,
I mean, applications
Right, Tony,
change
you're-
on the fly all the time.
Well,
When issues are raised, and, okay, we're going to withdraw that as part of our request. I mean, the testimony is what...
Aren't you going back and forth across the street now anyway?
You want to swear in the witnesses, Rich? I mean,
Well-
before they answer any questions, I can't answer that.
sure. So, can all of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Go ahead.
We need your names.
Can I just get the names? I
Names for
missed
the
the
record,
names
right.
at the beginning.
Yeah, they did at the beginning.
Karen Thompson.
Karen-
Karen Thompson.
Thank you.
Michael Slowick?
Thank you.
Paul Farnan.
Thank you. Got it.
We
Thank
will
you.
recognize that Paul is an architect,
Yes.
qualified. Okay? For the record.
Maybe it helps if Mr. Slowick just explains a little bit
So-
operational.
So the use of 502 has changed. It started out during the pandemic, we were serving food directly to the tents. Then the pandemic ended, and we didn't have any more seating. And
Can you please talk into the mic so I can hear you?
we recognized there was a great increase in takeout, and there still is. So we used that operation to, if a person comes in the Ugly Mug and does their takeout, in a normal situation, because the takeout is so much now, it would bury the kitchen, and the guests at the tables would suffer. So now since we lost the tables across the street, we send the orders from the Ugly Mug over across the street. That food is brought into the Ugly Mug, and then it's bagged and handed off to the customer that's waiting in the Ugly Mug. And it has two benefits. One, we handle the increased takeout, which we would probably turn off and lose that business. And then number two, you're not waiting 45 minutes to an hour on 4th of July weekend, and the guests at Cape May getting mad and walking out in July and August. So now you have a 15, 20-minute wait due to the relief. And the Ugly Mug's kitchen isn't much bigger than where Craig is to here, and what these tables encompass, if you've ever seen how small it is. So it's very small, and it produces a lot. So due to the overwhelming demand, it really helps us to use that as a takeout. And we have runners that carry the food across the street into the Ugly Mug's expediter area, and they bag it up and hand it to the customer. It's produced across the street completely. And
Can I ask a question? Pardon me, a question. Microphone. Thank you. The change that, I know there's some discussion, but just so I understand the change, is that the plan is no longer to serve to the Ugly Mug tables? Is that the change that we're talking about?
Yes, Mr. Mayor, yes.
Why would you make that change? I mean, I'm just speaking operationally, not legally or planning board wise, but wouldn't you want to apply to be allowed to serve those tables in times where you were backed up in the kitchen?
you asking me?
Yeah.
I would say
I'm saying
yes.
why the change? If certainly understanding that what you're trying to say is you're trying to do takeout, which we all understand. But if you had a backed up kitchen, wouldn't you want to be able to serve some of the tables across the street?
The issue there, Zach, is that now you have two businesses operating out of one building.
Right.
It's not one retail operation, even though it's two different items. It's now a restaurant and a retail store. in that case, you need a use variance. It's got to go to the zoning board because you're not allowed to have two primary uses in one structure. So that's the.
It just
I'm
makes
not- I'm not-
it a much more difficult application, in my
When
opinion.
you have
to go
people
to the
sitting.
zoning board either way.
When you serve food to people sitting down, that makes it a restaurant. What they're claiming is that they are not serving to people who are sitting down, they're serving for food to be taken away, and they're calling that prepared food. and
Retail
therefore,
sale, right.
Retail and prepared foods are permitted in the zone.
My point is, if there's going to be the case that they have to go before the zoning board either way, why
It's
not make
it's not
that?
either way.
Okay, okay. It's not, then that answers the question.
Can I ask a question, please? I'm still confused about the takeout. So this site, which is the old Stewart's, that's going to be strictly takeout, pickup at that location? You're not taking anything across the street?
No, we are. The
You are.
food is carried, if you came in the Ugly Mug and ordered takeout, the takeout computer would relay across the street to 502 Washington. The food's prepared over there, and a runner would bring it back into the expedite area of the Ugly Mug, and bag it up, put the condiments in it, and hand it to you.
Can they,
You probably don't have a cash register across where the kitchen is.
I was going to say, why wouldn't you just have the Ugly Mug and Ugly Mug takeout over here, two separate?
Well, what happens is they don't know about that, and everyone comes in the Ugly Mug for takeout. So to direct those people across the street is kind of difficult because they know the popularity of the Ugly Mug. They walk in and take out and order takeout.
Excuse me just a second. I have to react to that statement. That's clearly above and beyond. If you operated a new business, you would inform the customers that that's what the business is. You're creating the image that hungry people are wandering around Decatur Street looking for where their food is. They'll know where your pickup operation is if you say, here's our new pickup operation.
Well, I disagree with that.
You do? Okay.
Because the majority of people for the last 50 years walk in the Ugly Mug, go to the end of the bar, and order their takeout. They've done that forever.
And you couldn't put a sign there that said our
You could.
takeout's across the street?
You could, but the people,
Wouldn't want to do that, right?
oh, we could do that.
the question is, can you do that and would that make it a better operation? If you're having food not only
I mean, you
prepared, but also
could, but
picked up?
now the people, it's just a kitchen over there. Then now they're going to stand outside and wait for their food, where they would most of the time stand inside the mug and have something to drink or wait for their food there like they traditionally do. Now, if you direct them outside, now they're lined up in the hot sun. We only use this from May 15th to September 15th. It's closed now. It's just in our peak season to take off the pressure for the takeout. And then the mug goes back to just the Ugly Mug, and 502 is just a storage building for the other 8 months.
So there's no prep kitchen there for things you serve at the tables? like-
Not in 8 months. The 8 months it's closed, no. There's an,
No, no, in the summertime.
in the,
Is it the prep kitchen for the restaurant operation, or is it strictly for takeout?
oh, well, you have to prepare the food there, so yes, we
So it's a-
prepare the food in that kitchen, we make the food in that kitchen, and we walk it across the street, correct?
The question, I believe, is do you prep food for the Ugly Mug?
Diners, the
In-
seated
in-
seated diners.
No,
Inside
that,
dining.
the Ugly Mug itself has its own prep kitchen upstairs. And 502 has its own prep area, and storage and cooking.
And when this operation became, a couple years ago during the pandemic, Decatur Street was closed.
Correct,
Now it's open, it's a public thoroughfare in the middle of the Washington Mall complex.
that's right.
It's going to be the venue from which you are running back and forth across the public street.
Correct. And if you understand the mall, about 500 to 1,000 people an hour walk across Decatur Street. So my one person walking across with them is not by himself, is going to get hit by a car or cause any problems, because it's like the Wildwood Boardwalk on the Washington Street Mall across Decatur, June, July, and August.
Good.
Yeah, Mr. Monzo, I understand me, I got no issues with the Ugly Mug, and I don't vote on your proposal. I'm not a voting member. I just want to make sure that it gets done properly, okay? And whenever things change on the fly, it gets trickier. And I would just want you to ask for what you want to do, and then let them decide if you can do it, all right? And it sounds to me like you're operating a single restaurant. The initial application, it sounded like the two businesses were connected. People were going back and forth, and it was a restaurant, and then they were cooking on the other side, and they're going to go back and forth, and the board was going to vote on that. Then you said, well, no, they're two separate things. It's a packaged goods, it's a prepared food store, and it's a restaurant over here. And I wasn't even sure they got the same name. I thought one might be, Jimmy's Hamburgers, and the other one be the Ugly Mug. It's very clear based on the sworn testimony, at least to me, the non-voting member, that this is operating as one unit, that the Ugly Mug is going to have people ordering at the bar, and then they're going to cross the street and get it, or people are going to bring it back over to them, and it's going to have the same back and forth, all one restaurant, the Ugly Mug. The Ugly Mug's takeout kitchen, and the Ugly Mug with the takeout food being handed over the bar like they've done for decades. So if that's what's going to happen, then I think that's what you have to apply for, and then maybe you get it. I mean, everybody might like it, but it just, to try to create it as saying, this is a clothing store with a prepared food store, and there just happens to be this restaurant across the street, and they're totally.
Can I ask a question? If you vote on what the application is today, does the application say that it's that kitchen serving food to Ugly Mug patrons? Is that what that application says? You can vote on that today?
No, we
'Cause
can't.
Oh, you can't vote on that?
So the question is whether you can limit this business to the sale of food from that business and not a crossover to the restaurant across the street. Because if you're operating out of one building and you're selling food out of one building, it's a separate business is not connected to the restaurant. Right. I think what the concern is, if you're going back and forth with food, there's still no on-site consumption. I mean, I think that's a critical element, because what is it?
I get it. If you
If there's
open,
no on-site consumption, it has to be the retail sale of food.
it just sounds like you're operating two businesses together in two different locations.
And can you vote on that today?
But I think the board, at least as a matter of policy, wants you to tell us what you want to do, and then we can approve it or not approve it. You have to believe in your own business model. What we don't want to do is have the board approve something, and then that's not what you're doing, and that's not good for anybody.
But here's the question I want Mr. Slovak to address, and I understand what your concerns are. Is there anything that would prevent you from just sending any customers that order takeout food, just send them to the takeout kitchen to do the transaction there?
There's nothing stopping us from doing it.
Is it something you're willing to do as part of this presentation to make sure that you're not delivering food to the Ugly Mug, that all the food pickup and delivery is from the Ugly Mug
Tony,
takeout?
why don't you have this conversation with him outside the record? Because he's looking like, well, I know what I'm supposed to say for it to sound the lawyers want, but that's not how I run my business. So I just take a minute with him, and then if he comes up and says what he wants to do, the board can hear it, they can vote on it, and if he loses, you can always come back and do something different. But I don't think everyone's reacting negatively to necessarily what he wants to, but they got to know what he's going to do. I mean, and I'm trying to make like tough legal things. I'm reading cases, and I don't really know what he's applying for. But if it's a restaurant and he's sending people over there and then they're running things back, it sounds to me like it's a restaurant that has like a satellite section to it. And if the two businesses are operating in two places, I have a whole bunch of other questions and concerns about the application.
And I don't think it's,
There's no notice for the other property that's operating in conjunction with this one. It's very, I just, tell me what you want to do, and then we can talk about how to get it here.
I mean, you might want to just decide he wants to go to the zoning board to get the two of them combined, working together, as opposed to this bifurcation that we're talking about.
Well, the first, again, it still may require some consideration as to whether the delivery of food to another restaurant is running a restaurant from the delivery place. Because again, a restaurant is defined as something that has on-site consumption. I understand the connection that you're making.
But don't you
It's
place the
not-
order at that location? I mean, don't you pay at that location? Aren't the employees at that location? So.
No, there's employees, there's 5
So
employees. in the
it just
takeout
starts to
kitchen.
sound to me, it's like Peter Shields coming in and saying, oh yeah, we want to do all our takeout from across the street. That sounds like they're operating the restaurant partly across the street. So I'm just having trouble with, I thought that you're opening an independent, I thought you were doing what you said you were going to do, which sounded to me like it was the same restaurant, no question. The employees are running back and forth. But now it was going to be independent, like it's its own little takeout place, like Tommy's Hot Dogs. Okay, they're running Tommy's Hot Dogs over there. Is that prepared food? You know, then we can have that discussion and maybe the board votes on it. All right, fine. But now it sounds like you're running like Tommy's Hot Dogs and, you know, the Mad Batter are like the same place, and they're just across the street from one another, and you go pick up your food over at Tommy's Hot Dogs, and that is,
That's where I had the issue. The intertwining of the restaurant and I refer to it as a satellite kitchen because it doesn't fit in any definition of the permitted uses. I looked at it as the Ugly Mug expanding their operation across the street because they didn't have enough kitchen space to adequately accommodate whatever, because you're ordering off the Ugly Mug menu, correct?
Yes.
Okay, so to me, it's an expansion of the Ugly Mug across the street, and the ordinance doesn't contemplate that. So that's why I raised the use issue. I didn't raise the two use issues that the attorney did, but I just have not been able to fit what you're proposing to do under our strict definitions that are of the permitted uses, and that's why I raised whether it's a permitted use or not.
so, I mean, the board will take its, the chairman and all smart people here, they'll decide what they want to do, just in terms of the legal part, I will eventually have to give them instructions on what the standards are and what they're granting, and it's a challenge for me. I'm not, and I'm not, I think I get a sense there's people here who want you to succeed, right? But I just want to ask for what you want, and then maybe they can give it to you, you know, but,
So do you want us to take a break, Rich? And
yeah, I mean, maybe that's the way to go.
yeah, just give us 5 minutes.
All right.
Please turn off your microphones, everyone.
You can put that on, Siobhan, you can put that on Facebook and say, see, I really do own a suit. I was gonna do that, but I don't know if you were embarrassed.
I'm too hard to embarrass.
You want one deposition, you know what I'm saying?
Okay, we're back in session, and sorry for this late notice on my part, but I just realized that I own a property within 200 feet of this. I have a parking lot behind the mall, and the notice must have gone to my partner, because I don't remember getting it. I started looking at the list within 200 feet, and it's in there, so I'm going to step down. And Mike, I guess you can take over?
Sure thing, boss.
Yeah, sorry about that. Sorry about the,
Michael, straighten this out.
he will, he'll straighten it out. I'll stick around for the next thing, though.
Comments? Go ahead. Mr. Monzo wants to put on a little bit of...
Just that we want to just supplement the record. And thank you, by the way, for giving us the opportunity to convene and kind of clarify some things that I think are not clear. So I'm going to just ask Mr. Slowak to talk about not only what he's doing now, but what he's envisioning for this takeout kitchen and the opportunities he'll have for expanding his business. So if you want to just expand on that, Mike.
Sure, I just wanted to add that at 502 Washington, people can come up and order food directly from there. Sorry. At the location, 502, people can come up on the street and order food from there. So I just wanted to add that. So customers can be walking down the mall and without going into the Ugly Mug, you know, although they do go in the Ugly Mug and order also, but if you're walking on the street and you walk by that kitchen, we don't have a sign there yet because I didn't know if this is going to be a permanent thing for me. So we didn't go and put a sign up. We're going to put a sign. The sign will say what it is, and we will have the ability to serve there directly in addition to people coming in the Ugly Mug and doing takeout.
What about delivery services?
We've talked to delivery service, and we will add delivery services when I get a firm okay that I'm allowed to use it for that, because it morphed so many times, we didn't know where we were going to end up.
Follow the money. Where's the money going?
Exactly.
But where is the money going?
Oh, it's-
Where do they pay?
They pay at the Ugly Mug, but they can also pay direct, because everything's credit card. We have computers at 502, there's two of them, and a server or a runner, you can walk up, order food, take your credit card, and pay right there. So it has its own pay location. I can show it to you right now. We can walk across the street. Printer, just exactly the same as the mug. It talks through Wi-Fi.
So I really don't have any more testimony. I do want to just add one or two comments, and I would ask that you vote on the need for a use variance. And depending on that vote, then we can deal with the rest of the application. And if we need a use variance, you know, we would suggest that this matter be administratively transferred to the zoning board. But I do not believe a use variance is needed. I mean, a eating establishment is a separate use, which is a restaurant, which requires on-site consumption of food. This is a business that is strictly a small area that has 5 employees. So this area in and of itself is not creating any more intensity to that building than the sale of retail clothing, other than the fact that you may have 5 additional employees, which still keeps the parking significantly lower than a restaurant. And I think the mall, the Washington Street Mall, not the Center City Mall, but the Washington Street Mall is kind of unique. And there are so many businesses, and there are so many buildings, and the ordinance says one building can only have one use. Well, there are several buildings that have 3 or 4 uses. And whether they're all retail or part of it is a restaurant, part of it is retail, it really doesn't matter. There's still many uses in many buildings along the Washington Street Mall, and it's really no different than a shopping mall, but it's outside. And, buildings change all the time, and uses in buildings change all the time. And to require a use variance every time there's a change or an additional use, I can understand from a planning standpoint, if you're cramming an intense business into a small spot and it's becoming to look like a bazaar, it's one thing, and that's not what the intent is, and that's not what this plan calls for. This is clearly takeout food, and Mr. Crowley asked the question, do any other restaurants deliver food outside of the business location? And it happens all along Beach Avenue. Almost every large hotel that has the concessions along Beach Avenue deliver food across Beach Avenue to customers that are sitting on the beach. So it's not totally out of the ordinary. This does actually benefit because it takes some of the congestion away by having the ability to just get takeout food done on a quick basis so people are in and out, or to have people just have it delivered to their home as opposed to creating more congestion and more parking issues along the Washington Street Mall. I think DoorDash would be an excellent fit for this kind of business. So I think forward-looking, this gives great opportunities for the Ugly Mug as a separate and independent part of its business to focus on takeout and delivery of prepared foods. So I would respectfully request that the board consider all of that in voting as to whether this requires a use variance. And if the board's answer is it does, we'll deal with that. If it's no, we'll address the other comments that Mr. Hurlis had in his review memo. Thank you.
Did the 200-foot list go from 502, or did it also go from the Ugly Mug?
I think we asked for it from 500, 502. We didn't, the Ugly Mug wasn't the site for the application. It was 502, so, I say 502, I think it's 500, 502 Washington. It's the building on the corner.
Well, I'm gonna give you my thoughts on the law and the ordinance, but you guys are ultimately gonna vote on whether you think that it's appropriate that they go to the zoning board for consideration of a variance. I also, respectfully, I didn't get to study Mr. Monzo's case as closely as I would like, but I have read that case before and had the issue before, and I really think there's a difference between a planning board making a decision that is very use variance interpretation heavy, and then it being okayed by the court later after they've done it, versus a planning board at the outset wondering whether they should be deferring to the zoning board's use variance analysis at the outset. And I suspect that the court might have ruled differently if they had been presented with that question the night the planning board started its process. But leaving that aside, you have an ordinance that says each site shall have only one principal building, structure, or use. You then have the C1 primary business district, and that lists the uses by right. Subsection M of that says retail sale of goods or prepared food. Question is whether a takeout restaurant is prepared food. Maybe it is, maybe it isn't. That is what I thought you guys might have to kind of decide. Because I'm not even sure that having a clothing goods store and a prepared food store in the same building is necessarily the same use just because they're both under subsection M. Because they sound a little different to me, but I would let you guys decide that.
Rich, can I just ask, when I read that, it sounded like there were two retail clothing stores. It's only one and the one restaurant? Okay.
Kitchen.
The kitchen. Okay. And can I just ask one other question that, in my mind, might make a difference to some people sitting here, too? I see that the Cape May Fire Department signed off on an inspection. What exactly did they inspect for, since we're really not sure what the usage was? And is there a firewall? What prevention is there for that retail store?
Have Paul answer?
Yeah, Paul can answer.
That's what I thought.
It's only one.
It's,
One retail store.
Retail
I can-
clothing and retail.
right. I can speak to that. So there's two mercantile functions.
One is the food, one is the clothing. The clothing store is 2 levels, so that may be where there's some confusion.
Your plans refer to retail unit 101 and retail unit 201.
Indicating on the plan that's the second floor level.
Same,
Same proprietor, yes.
Okay.
my review shows them as 2 units, but testifying that it's
That
It's
was my
correct.
confusion.
That's
Thank you.
correct. It's correct. 2 floors, just as it's existed since it was a bookstore. To answer your question regarding the fire approval,
Yeah.
that is the separation that's required between a commercial kitchen.
So it is
and
in place?
Correct.
Okay.
We also have approval letters from police and public works as well.
I see that, but I was curious about the fire because I knew that was a bank before and it was separated. I didn't know if a firewall was installed. Thank you.
Okay, so, for example, they were selling, next door was the cheese shop where they sell what I consider to be more classically prepared foods versus, and a retail store. Then what you guys would be trying to decide is if having a retail store and a prepared food store in the same building required a variance. So that was 2 different uses in the same location. But the testimony, at least to my ears, indicates, at least to me, that what's really going on, and it's not a criticism, it's just what I think the testimony is that the Ugly Mug, which is clearly a restaurant, clearly a drinking establishment, restaurant, is operating its takeout portion in the building behind the retail store. And that the 2 are really part of the same use, that they're working off the same menu, the employees are exchanging back and forth, they're running back and forth, they're connected electronically, they're collecting money from one for the other. So to me, in my opinion, the use that's going behind this retail store really isn't a prepared food. It's just the takeout section of the Ugly Mug. I mean, that seems to be what it is. That's not a criticism, that seems to be what it is. And that really starts to sound like a use variance. And maybe one to which they're entitled, and maybe the zoning board likes it, but that's just my view of it. But I don't vote, okay? I'm just giving you the means to think about it, all right? So however you guys vote, but I think what you need to vote on is whether you believe that this sounds like, that is to you, that this is a use variance, that it's the Ugly Mug operating together with a takeout component across the street that's behind a retail store. And if you think that that needs a variance, then I think you should send it to the zoning board. If you don't think it needs a variance, if you think that what they're doing is really a retail sale of goods and prepared food, and you think that's okay to have both of those in the same location, and that's what this is, then you can vote to keep it here and handle it, okay?
Rich?
You want me to explain it again? It's complicated.
Well, I don't know, Craig, could you explain it the way that you state again what you had stated earlier from your review? Because it just made it clearer to me, I think.
Trust Craig more than me. I'm more than happy to listen to him.
So from a planning standpoint, this is a board of permitted uses. This board only has jurisdiction when it's a permitted use. So that's why we have to have this discussion before we get into the site plan aspects of this project. So we have to, the C1 primary business district has a list of permitted uses. We have to find that it meets one of those uses. And there's also, as Rich brought up, there can't be 2 principal uses on a site. So if we have all retail uses in that building, I think you're fine. But this is where the lines start to get blurred is, okay, they're saying it's the retail sale of goods or prepared food. Across the street, the Ugly Mug, I think, meets the definition of eating established designed for on-premises consumption, including those having outdoor table facilities, provided that such facilities are portable and within 10 feet of the principal building. Drive-in facilities with window or curb services are not permitted. In my opinion, I think that the Ugly Mugs use, that eating establishment use, is getting drug across the street into the site we're dealing with tonight. That's the determination I think we have to make.
So basically, what you're saying is that it's not necessarily our jurisdiction, and it belongs to zoning?
If you think that the Ugly Mugs use is across the street, I don't think you can find that there's not two uses in that building, and therefore it needs to go to the zoning board for their to hear, because they're the proper board for the jurisdiction.
If he came in here and said, I'm sorry, what's your name, sir?
Michael.
Michael. If Michael came in here and said, look, we sell ton of Reubens, we make them great. So we want to open up, it's called Mike's Reubens. And he's going to open that up over in the Stewart's building there. And it's going to be Mike's Reubens. And it's a separate business. He owns it too, but it's a separate business, Mike's Reubens. And it all happens there. Then they would say, well, we think that's prepared food. So we are opening a retail sale of goods and a prepared food store. And then I'd have you guys decide if that's two different uses. Since it's under Section M, maybe it's one use, and you guys could decide that. But that's not what Mike is doing. What Mike is doing is he has his Ugly Mug. He's wildly successful, that's great, and he wants to take his takeout part of his restaurant, which now happens inside theoretically happens inside the Mug, and he wants to put that across the street along with a retail sale. And what I'm asking you guys to decide is if you think that is just like having a prepared food store there, or if that's really like having part of his restaurant there.
Rich, the sale takes place in the Ugly Mug. The delivery of the food may or may not take place either in the Ugly Mug or across the street. Is that fair?
I'm not sure where it's taking.
The sale takes place at 502.
In the Ugly Mug?
No, that 502 has its own computers. So even if you came in the Ugly Mug and ordered takeout, the sale goes to the computers at 502.
What the bartender takes the order.
No, a server that goes across the street that
But
is
in the
getting,
Ugly Mug, they take the order, they put it in the POS right there.
if they came in the Ugly Mug, yes. Correct, yes.
Can I just, if I may, Rich?
So,
I'm sorry.
so regardless of whether we, I don't know how to word this, but let's say agree with the fact that that function is reasonable and something that actually could enhance the area is one thing, but what our responsibility as a planning board, based on existing ordinances, is really what drives us, correct?
Yeah, Mr. Monzo was
if I said
talking
that
about
right.
the intensity and stuff like that.
Yeah.
That shouldn't be weighed at this point.
That's,
You're strictly saying, is it permitted or is it not permitted?
Well,
Whether it's a less intense use or it has nothing to do with it. It's,
yeah, regardless whether it enhances the area. or
those are,
anything like
those
that,
are
it's a good idea.
things that you, considerations of use variances and other variance type, so.
All you're doing is listening to the testimony, hearing what his use is, and deciding if that's a permitted use or not a permitted use. That's all you're doing. But I'm trying to help guide you to the part of the regulation that you're basing that decision on. And you can have one principal use, and one of the uses is Section M, retail sale of goods or prepared food. Okay? There's another section, eating establishments, Section H. One possible understanding of this is that they have an H and an M, a retail sale and a restaurant kind of happening all together in two different buildings kind of mushing together. That's one interpretation. You may all say, hey, we think it's a retail sale and prepared food in one building. We don't even think that, we think that's permitted. We think that's okay. And then you guys vote that you want to do it. That's all.
can I just,
I don't vote.
I just want to respond, because this is not, does not fit, in my opinion, in an eating establishment. Because basically, you're saying that's an expansion of an existing business across the street to a separate building, which is not, what is it at that point? I mean, if you're going to...
That's why I'm having...
But if it's that, that's not permitted either. I mean, if you look at what's permitted, it's retail sale of prepared foods in one category and eating establishments in the other. So if you have a kitchen that's selling retail prepared foods on a retail basis, which this is doing, what difference does it make if it's delivered across the street, down the street, across the town, or picked up? It's still the retail sale of prepared foods. And to try to say it's a restaurant, to me, doesn't fit at all into the definition that's in the zoning code, because a restaurant or an eating establishment is designed as a place where food is prepared and consumed on site. And that's why I talk about intensity. And restaurants have significant intensity because people are sitting there waiting for their food, they're waiting for a table. None of this is happening here. So I'm not saying intensity has nothing to do with it. With use, it probably doesn't, but in terms of your analysis of it, a retail store is much less intense than a restaurant. And that's why the parking calculations are much different. And that's why I view all retail, regardless of whether it's food or clothing, as permitted in one building. So, I mean, that's my argument. You heard, your professionals weigh in on this, so.
If he wanted to sell his T-shirts from a store across the street and they just sold Ugly Mug T-shirts and it was separate, then that's a different thing. But they sound very connected to me. Employees are running back and forth, placing orders at the bar for food over in another building. It's just very connected.
And you're absolutely sure that no food served at the tables of the restaurant is going to be prepared in the bank building? Is that what you're saying?
Yes.
That goes on the record?
Yeah, I mean, we morphed into that at one point during the pandemic.
Now we're going to morph back.
Well, yeah, because there's no more tables that we can serve in the street.
No, I'm talking about the tables in the restaurant.
No, there's no need to, because we don't have we had 3 tents outside at one time, with 30 tables outside.
No, I think what he's trying to say is that if somebody comes to the bar in the mug, whatever he orders, that's being prepared across the street?
If it's from our busy season, May 15th to September, and they order takeout, it funnels across.
But then you're not going to make that tavern, that person at the bar, go across the street and get it. He's going to deliver it across to you.
Correct.
And you're also not going to make
Correct.
the day's
We have
order
runners.
of French fries over across the street and then bring them over for service in a restaurant?
No, we have the Mug's Kitchen for that. It's much faster. Yeah.
There's a statement in your justification. Can I read it? And you tell me whether this is what you propose to do or not? The retail kitchen will also alleviate some of the overflow from the Ugly Mug Kitchen, which will reduce wait times and improve customer service. In this regard, servers working on the outdoor patio will be able to direct food orders to the POS in the retail kitchen. Once the food is prepared, a retail kitchen staff member will take the food and deliver it to the server utilizing the appropriate crosswalks at all times. Additionally, many of the call-in takeout orders for the Ugly Mug will be routed to the retail kitchen where the food will be prepared and picked up.
That was a year and a half ago. during
Okay,
the
so what is not,
we would just use it just for takeout. So,
Okay.
so that says that we're going to make food at 5:02 and bring it over to somebody sitting at a table at the Ugly Mug, because that was 15 months ago during the tail end of the pandemic. We're still under COVID. So now we decided that we're just going to, the Ugly Mug's going to serve all their tables, and that kitchen is just going to service takeout. And it improves service automatically because now the Ugly Mug's primary kitchen is not burdened with takeout, which is now much more significant than it was in 2019. So we would get 200 orders a day, let's say, now and during COVID, as takeout in the Ugly Mug's primary kitchen. It would bury the kitchen, and you'd be waiting an hour for your hamburger sitting at a table or sitting at the bar for a hamburger. Now that takeout order gets routed across the street, and those people are either standing there waiting for their food, or if we try to direct them over there, they'll pick their food up across the street. It's a combination of both, but it improves service either way. And during the initial application, which is, we were using that kitchen for tables on the side of the Ugly Mug where the barrel is. They were using that.
It makes sense. It's a close call, and my position legally is not, sometimes I tell you guys, if you're really that, I really think you need to do this particular thing. I'm not saying that. I get it. They're just, they're doing takeout, and they believe that's prepared food. They're only doing the takeout over there. It's being ordered across the street at the Ugly Mug sometimes. It's being brought to the Ugly Mug sometimes. I don't know what to make of that or what to do with it. That's why you guys get the big bucks, so.
Mr. Chairman, we've been talking for an hour on a set of documents that are almost a year old, after we've spent a week reviewing a set of documents that are less than a week old. All of this is verbal. It's floating in the wind. Is there a way we could just simply step back for a month, get some fresh, accurate documents from the applicant, and then think about them? Because this conversation is floating around the room like a helium balloon. Let's get ourselves a set of documents that we can then transfer into a debate, which then becomes part of the record and a decision. This is way too verbal to act on tonight.
I mean, I personally agree with you, because I'm kind of dealing with it on the fly a little bit, because I didn't separate these two things the way you did.
Yeah, and we can't have
There
side.
were waitresses running back and forth serving stuff, and it sounded like a restaurant. And now you're really separating them, and maybe you can convince everybody that it's going to have prepared food and a clothing store in the same building, because they're really the same use, because they're both in Section M, and they don't need a variance, and maybe you convince them of that.
If I can address that, and I do appreciate that, Mr. Crowley, I think it's a good suggestion, by the way. There's no pressing need
No,
right now.
because you're not doing it anymore.
Yeah, and I mean, it's been something that the city has been asking us to address, and we apologize for taking so long, but there were some issues that we needed to.
Well, let's table it and then get everybody's paperwork in order for the
So
next time.
we can just resubmit, just amend the application to address the justification
Can you
section.
submit a business plan? No, I don't mean like, you know, an IBM level business plan. I mean, just in advance, can you just write clearly what you're going to do and not do, and then we have that in the record, everybody can
You can do
read it, and they can know that that's exactly what you're doing.
Okay. That's a good suggestion,
And
so.
you and I can go over a little bit to try to deal with this with food, and if you need a use variance.
Okay.
I think it would eliminate some of the confusion for some of the definitions that are.
There really is some confusion about, I mean, I like Craig's word of a satellite kitchen across the street. And that would require a variance. And if you can get past the fact that it's not a satellite kitchen, then I'm on board. But right now, I'm almost that way right now. That's a satellite kitchen, and that's not what we can improve. We can improve here.
Sure.
Okay?
Do the right thing.
Yeah.
Okay.
Okay.
So we would ask that the board entertain a motion to table this until the next.
Do they need to re?
What's the better way?
Rescind.
Table or withdraw?
Can I,
I'd let, oh, good, Mayor.
well, just one question before we do that, is, could we hear public comment, or would that be appropriate or not appropriate? The reason I'm asking
I
is,
always think it's appropriate to hear public comment, and that's my general.
I'd like to hear if anyone was here, I'm just telling you what I'd like, you can tell me I'm wrong. I'd like to hear if anyone was here to speak for or against or whatever, this evening.
I think this is more
It's chairman's
jurisdiction.
discussion, I got nothing to do with that, so.
Anyone out there would like to speak?
Make a motion to open to the public,
I'd like to make a motion to open the meeting to the public.
and then they can vote, and then you can just, and then say.
Second.
Is there a motion?
Yes, we have a motion by Mr. Jones, seconded by Mr. Lundholm. Mr. Gorgon?
Yes.
Mayor
Yes.
Malik?
We're just voting to open it up to the public?
Yes, sir.
Yes.
Okay, Councilmember Yeager?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes?
Mr. Lundholm?
Yes.
Mr. Malloy?
Yes.
Mr. Paducis?
Yes.
Mr. Jones?
Yes.
Okay.
Anybody want to step forward and speak? You're more than welcome. Seeing none, I guess we close the meeting to the public. Okay?
Thank you. I just wasn't sure if anyone was here to speak.
Do you also want us to keep you? All right, we'll decide next time if we're going to send you to the zoning board as well. I was just trying to see, you may decide you want to go there. All right, so it's being tabled.
Motion to table?
in the interim, as I understand it, they're gonna submit a business plan to clarify their intended use. And we're also gonna try to get our thoughts together, Tony and I and Craig, as to whether or not, so we can better guide you as to what their business plan is a permitted use or is not a permitted use, so we can offer clear opinion on that. And then ultimately, you folks will decide if that business plan as proposed is a permitted use in the C1 zone. If it's not a permitted use in the C1 zone according to you, they have to go to the zoning board for it. If you believe it is a permitted use, then you'll address the site plan issues that are implicated. Okay? Does everyone understand that?
Do they
You
need
have a
to,
question, or are you just quizzical, or are you okay? You good?
do they need to resend a list of notification? To adjoining property owners?
No,
Oh.
the jurisdiction or the...
I was just asking a question if zoning could challenge that if we made a decision.
If the zoning board would challenge it?
If they could challenge our decision.
No. Someone could go before a member of the public could appeal that and say you didn't have the jurisdiction for that, or they could go to the zoning board and seek an interpretation. So someone else could do that, but the zoning board isn't likely to do that. I'm also the attorney for the zoning board, which helps the communication. You got a question, Mr. Chairman?
Do they need to resend adjoining property owners notification?
No, but I would say this, Mr. Monzo. I have some concerns about your notice. And between now and then, it's up to you whether you want to try to fix it or not. But I would also get, if it were me, if I was sitting in your seat, which you know I do on occasion,
I know what you're going to ask.
okay? Yeah, all right. What we're saying, I think he should get his notice from the Ugly Mug as well. It may add just 2 or 3 properties, so it's not a huge burden. He can send those notices out. For anyone who has received a notice, this application may be tabled. If it's tabled, there'll be no further notice. This is your notice. There may be some additional notice to some other people in addition, but your notice is that this will be heard again at our next meeting, which is,
I believe it's the 26th.
you want to make it, how about,
Do you want it in 2 weeks or next month? The next regular meeting?
you want to do it in a month, not in 2 weeks, right?
Month.
So the next meeting in October is when?
26th.
I'm trying to find it.
October
First is
10th, right?
second one's the...
Yes, October 10th.
October 10th at 7:30 to 6:30 at the same location. This is your notice. There'll be no further notice if this is tabled.
Can I ask a question about that? If a decision is made that it needs to go before the zoning board, is there a chance that it won't be coming back to the planning board then?
It will not come back to the planning board. If it goes to the zoning board, the zoning will have the use variance, and they also have the authority to do the site plan analysis that they need to do. It doesn't happen often, but they do it along with use variances. It will not come back to you if you send it to the zoning board, and we would send it administratively, meaning we wouldn't make them reapply, we would send it over to the zoning board with the same packet.
I mean, is that what we're essentially doing with tabling this? I mean, that's kind of my last question.
No, you're tabling it because you may come back next time, when you have a clear understanding of the business plan and have reviewed the permitted uses. You may conclude that that is actually a permitted use, or you may conclude that it's not a permitted use and therefore has to go to the zoning.
Okay,
Okay?
Looks like your notification letter was just for 502.
It is.
Did not include, okay.
So there's a motion to table?
Yeah.
Second.
Is there a second?
Second.
Who was that, Mr. Gorgon? Yes?
Yes.
Thank you.
Second.
We have a motion by Mr. Crowley, seconded by Mr. Gorgon. Mr. Gorgon?
Yes.
Mayor Mullick?
yes.
Councilmember Yeager?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes,
Mr. Lundholm?
Yes.
Mr. Malloy?
Yes.
Mr. Pedousis?
Yes.
Mr. Jones?
Yes.
Thank you.
Thank you. Thanks for your patience and giving us the ability to
You flush these in.
kind of clear things up. So
If I could just say, I hope it works out, because I do think, there's more comment on this actual application. The fact is, I see no problem personally with takeout. I think Cape May needs more takeout. I think we all know this. I've, as the mayor, received complaints about the fact that there's a lack of affordable food in Cape May. We know we've lost a few takeout spots. So I really wanted to say that as part of a vote, but I will say on your behalf, we have a well-established, respected restaurant in town wanting to do takeout. I think, my personal opinion, whatever we have to do to make sure it's done legally and in the right forum, of course, I totally support, but I'd like to see it happen. I'd be happy to say that. I mean, I think it's again, a respected, and again, no one here from the public to speak out against it, which to me seems to point to the fact that this is not a major outcry or anything like that to do this.
And if you noticed, since the pandemic, a lot of restaurants turned their takeout off.
Right. I've seen that.
Literally turned it off at 7 o'clock for the rest of the night.
Right.
Hardly any takeout places, even in existing restaurants.
Good luck with it.
Look at your business plan, and I think the more that those things act independent of each other to a greater degree, I think it helps your argument that it might be a prepared food thing as opposed to an extension of your restaurant. Okay, so that's where I would focus.
Thank you. All right, thank you very much. Thank you, everybody.
Okay, the next item is the master plan consistency review. Ordinance 492-2023, amending zoning code to clarify provisions regarding bulk setbacks to public property and non-conforming structures. Craig, you want
Sure.
to give us the highlights of this?
So I prepared a review memorandum dated August 25th, 2023. This is a ordinance that was proposed by City Council. The ordinance stated purpose is, one, to provide supplemental regulations concerning the installation of accessory uses in relationship to principal dwellings, and which provides for enhanced setbacks in relation to any street or alley. The second purpose is to clarify and confirm the intent to preserve increased setbacks in relation to all adjacent public property, which promotes the general welfare and preservation of adequate light, air, and open space in relationship to public property. And three, to clarify and confirm that in cases where a building is raised to meet flood elevation standards and modifications or relocations are proposed to the site, that no variance relief will be required if the end result of the modification or relocation is a site that strictly conforms in all respects to the bulk use and parking and density requirements in effect at the time of the modification. So in doing that, we review our master plan and and subsequent reexaminations. In that, our general municipal goals, if you take a look at those, on page 2 of the report under subsection 1.5, the proposed ordinance is consistent with subsection 1.5 A, B, C, F, I, and M. The ordinance also appears consistent with other recommendations contained throughout the master plan. There were no inconsistencies that I could find. So that being said, you can find it consistent with the master plan. If you want to go into the specific changes, they're highlighted on page 3 of 5. They begin there. That's the actual ordinance with the changes that are underlined and bold-faced. So if you see section 1, subsection E and G are being modified, and then under chapter 525-73, subsection A, there's a clarification added to the raising portion of structures. So I'm happy to answer any questions, but I believe that you can find it consistent with the master plan goals and objectives.
I do have a few questions.
Okay.
Let me see if I can I'll explain what I think I understand, and you tell me if I'm correct. Under the second section, talking about raising structures as a result of the flood specifications, what happens if we raise a building under this section of the code that exceeds the mandatory height limitation?
That's not permitted. This doesn't change that. There's a maximum allowable requirement that sets forth how far you can raise the building.
Okay, so that's the flood,
So it's, yes, so we have a BFE, which is your base flood elevation.
Right.
And we have a freeboard factor, and then they give an extra 1 foot to allow for mechanicals to be put in there.
so in layman's terms, what does that mean for a house on the street, let's say on Columbia?
So once again, the base flood elevation is like a horizontal plane that cuts through, doesn't matter how the topography goes. That BFE runs through whatever flood zone elevation you're at,
Okay,
okay?
Yeah.
And then we have freeboard, which is BFE plus 2, and then there, we give them 1 foot to get the mechanicals in, so it ends up being BFE plus 3.
so, and that would be then
So elevation, for instance, if you're in a flood elevation of 9, so it's elevation 9, plus 2, plus 1.
and then if that 9, 2, 1, that's 12, right? So if you raise that house 12, and then it exceeds the mandatory maximum height, that's not allowed?
It's not permitted.
How do you,
You're not raising it 12 feet. It's 12 feet above sea level, not above ground level.
That's the reference where you measure the height from.
Right.
yeah. Well, suppose you don't meet the minimum height elevation for flood, and you also bump up against the maximum height of a building. Does that make any sense to you?
Well, part of the way you measure the building height, Dennis, is from the crown of the road or 11 feet above sea level, whichever is higher. So your measurement is still going to be, let's say 11 feet, which is probably most of the town. It's 35 feet above that point.
Yeah, you're normally measuring from the base flood elevation because the streets aren't higher than that. So throughout town, I've never run into a case where
Okay.
we're actually measuring from the street.
Then the second part-
Dennis, aren't you just asking the question of who wins, FEMA or Cape May?
Yeah, right, exactly.
So
And that's a good question.
So if you're raising it, if you have an existing structure and you're raising it to meet flood elevation levels,
Yeah,
and it exceeds the building height, then that would trigger a variance,
okay,
okay?
all right.
But I could very easily justify my variance because I'm, meeting the
You're
flood standard.
complying with the flood
Yeah,
ordinance.
So, but
Yeah, okay.
I haven't seen many of those cases.
All right.
We have seen cases where the reason why that cap ended up in there with the limitation of how far you can raise your house is because they're being raised excessively high to accommodate parking underneath. In historic districts, it was just out of whack. So that control was put back in there recently, not recently, but within the last 5 or so years, I guess, to stop that excessive house raising.
Okay, and the second part of that section two confused me. If the property is being raised and in the process is also expanded, modified, or relocated on the property,
Yeah.
how do we prevent little houses from becoming McMansions in neighborhoods that don't want big houses?
Well,
Just because we were
you have-
raising it for the flood?
You have numerous other zoning controls that stop the proliferation of big mansions.
Well,
Floor area ratio, setbacks, lot coverage, all control that.
So if a homeowner or developer wants to do that, if he still winds up within the existing requirements, he can do that.
So
That's what this says.
it's my understanding that
Is that what this-
we had an applicant for building permits that wanted to raise their house and move the house. So the state law said you can raise your house in exact footprint and extend your stairs out, and you needed no variance relief. That's what the state statute said.
Right.
Okay? We had someone that actually was non-conforming with regards to, I think it was the side or the front yard setback, and wanted to push their building back more in conformity with the setback regulations.
Right.
We didn't allow the relocation. This allows the relocation, which promotes more conformity with
Okay.
the other Vulcan area requirements.
Okay.
So I think that's a good idea.
All right, I just want to make sure I understand what
That's where I believe this originated from.
All right. All right. Fine.
Any other questions? So we are voting to send this to council for approval?
So yes, you can, your recommendation is to determine that it is consistent with the master plan, and you're also allowed to submit any recommendations along with that, but that should be your vote. I'll let Rich pick up the legal part from there.
Somebody care to make that motion?
So moved.
Second.
Okay, guys.
Okay, we have a motion by Mr. Gorgone, seconded by, who's over there, Mr. Jones. Sorry about that. Mr. Gorgone?
Yes.
Mayor Mullick?
Yes.
Councilmember Yeager?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yep.
Mr. Lundholm?
Yes.
Mr. Malloy?
Yes.
Mr. Jones? Mr. Bezier?
Yes.
Thank you.
Okay.
Two quick questions, if I may, Mr. Chairman. Yeah, this will be quick. The council seemed to have had a problem with something we sent up to them, Section 524-4, the building setback discussion. That was a proposal we made to them, and they've been bouncing it back and forth at least twice now in their meetings. Should we review that again, based on that, or?
I've been requested to attend the next council meeting to explain the changes that we proposed to them. So that might take care of the issue.
Okay, all right. And the last thing is, as we search the master plan for things we ought to be doing, I want to remind the board that a couple months ago, we approved a property to build 2 apartments and commercial stores on Elmira Street at the bus station. And some of us were opposed to the notion that there should be parking, there should be allowed parking on that property. The master plan also said, page 77, said the back-out parking should not be permitted for commercial uses. And that's actually what we approved in that request. So I think going forward, I'd like to take a deeper dive into the master plan to make sure that we pick up things like this, because it bothered some of us on the board when we voted on that there would be back-out parking on that tiny little street with a traffic light on it. And in fact, the master plan says, yeah, that's not a good idea. And I think we should have picked that up.
I thought we didn't. I thought they had an expert traffic engineer testify that that is a low traffic area because people don't go down there and they avoid the light. And there was testimony from 2 or 3 residents who said the same thing. And said,
Well, yeah. Okay.
There was a variance granted for it, so the board weighed the consideration of the profession.
Yeah, well, I heard that testimony too, and I think if somebody says that's not a heavily traveled road, they've never been to Cape May, because that's the only way to get across town. It's only one of 2 ways to get across town.
But
And
it
we
was,
said that
it was
at the
addressed,
time.
it was addressed. It wasn't something that slipped.
No, it wasn't, but at the same time, I think that if we had said, well, wait a minute, even the master plan says that's not a good idea, maybe we should have backed up a little bit and done that. So my point is not to review this issue or revisit it. My point is, there's these nuggets all over the master plan, and I think we should be starting to dig a little deeper into it as we go forward, because that's our job.
That is our job.
Thank you.
Okay, thank you. Final motion?
Motion to adjourn?
Yes, sir.
I'll second that.
All in favor?
Aye.
Good night,
All in
all.
favor, yes. Thank you, everyone. Good night.